Okay, we've got a good number of attendees, so we can go ahead and get started. Thank you all for joining us today. I'd like to introduce my colleague, Liz Sanchez. Liz, you want to introduce yourself actually?
Hi everyone, I'm Liz Sanchez. I use she, her pronouns. I'm the VAWA U Visa Pro Bono Project Coordinator at NIJC.
Thank you, Liz. And my name is Trisha Teofilo Olave. I am the Legal Project Manager and currently the supervisor of our VAWA U Visa Pro Bono project. We also have Jackie Mattis, who is on our project, and Ellen Miller, who's our Pro Bono Manager. So thank you to everyone who put forth a lot of work to make this training possible, and for all of you who are here as attendees. I do also want to take into account the events of the day and this week, and just make space for that. As you know, I know that what's going on in the outside world affects all of us, and thinking of the people of Ukraine. So today we are here to talk about representing immigrant survivors of domestic violence and other crimes. We're going to talk about U visas, and this training is geared towards training attorneys and accredited representatives and people who are preparing U visa cases. Okay, it is not meant to help people practice unauthorized practice of law. However, if you're a paralegal or someone who works with attorneys or accredited reps, you may find this training to be helpful also. But if you have questions about that or about the unauthorized practice of law, we're not going to go over that in today's training, but I encourage you to reach out and we can answer those questions separately. So I'm going to talk very briefly about NIJC, the National Immigrant Justice Center. And then we're going to talk specifically about some of the various pro bono projects we have here at NIJC. So NIJC is a great nonprofit organization. We're part of Heartland Alliance, and we have a very unique approach to the work that we do because we do direct legal services, but we also have an amazing policy team and a litigation project. And so we combine that federal litigation with our national and local advocacy, with our direct legal services to really impact the work that we do and impact change for our clients. We have a huge pro bono network, and we are able to serve many more clients in thanks to volunteers like yourselves who work on these cases pro bono for our clients. We're a nonprofit agency, right? So we are limited in the amount of clients that we can serve. But because of our wonderful volunteers, we're able to reach so many more clients. So we're going to talk about the pro bono projects, and then we're going to talk about U non-immigrant visas, the whole purpose of today's training. Liz is going to go into specifics on working with survivors of domestic violence because many U visa clients, not all, but many are survivors of domestic violence. And we have some helpful tips that can make that relationship between you and your client stronger. Liz is also going to talk about the nuts and bolts of preparing a U visa case, the procedures, and what this process looks like. And then in the end, we're going to give you some lots of actually reference sources and contact information. We have a wonderful U visa pro bono manual and some handouts that you can find linked here in the handouts section. And then as you have questions, please feel free to type those questions up. We'll try to answer those as we go along, but if not, we'll come back to them at the end. Okay, so NIJC has a number of different pro bono projects, and if you are interested in volunteering with any of our pro bono projects, I encourage you to reach out to myself or Ellen Miller, or really any one of us on the NIJC staff, and we'll point you in the right direction. We have an asylum pro bono project, a detention project that helps with immigrants who are currently detained, our litigation project. We have some clinics that are case type specific, such as DACA, Deferred Action for Childhood Arrivals, and naturalization, and also post-asylee and refugee benefits. We have a children's project, which helps with special immigrant juvenile status cases and obtaining predicate orders in state court. And then last but not least, our VAWA and U-Visa Pro Bono project. So the way the pro bono projects work here at NIJC is usually a client, an immigrant, comes to NIJC seeking assistance in their immigration case. And NIJC staff conduct a thorough screening and assessment of their case to determine if they're eligible for any form of relief. Now, sometimes clients already know or have an idea that they might be eligible for something. Maybe they've heard about it from someone else or from an outreach presentation, but we try to do a thorough screening to see if they might be eligible for anything else. And then once we have determined they're eligible for relief and that they're ready to move forward, we will accept their case and sign a retainer with the client in order to begin that case relationship. We also then, if we have a pro bono project dealing with that kind of case, we will try to find a pro bono attorney to work on this case. At the same time, we train the pro bono attorneys, like yourselves, to be able to prepare these cases very well. Once an attorney accepts the case, NIJC still remains of counsel. We provide technical support throughout the life of the case. We will review documents and filings and technical assistance. We also provide liability insurance. So the various roles and responsibilities are laid out pretty clearly right here. NIJC provides outreach to various places in the community, such as domestic violence shelters, schools, hospitals, clinics, domestic violence agencies. We create the case referral packets that we send to the attorneys once you take on a case. We provide the training and the support with technical support, reviewing filings, case strategy. We provide policy updates, malpractice insurance, and we remain of counsel. And then you as the pro bono attorney also need to take on this case and prepare it, obviously, to the best of your ability. But before you even take on the case, we ask you to do a conflicts check. And then pretty quickly thereafter, from accepting the case, we ask you to schedule a client meeting. We would hope that you can try to prepare the case within about 8 to 12 weeks. And if it's going to take longer than that, check in with us and we can help strategize if there's a particular delay in the case. We ask that you represent the client for the duration of the case. And if for whatever reason you can't obtain, then we ask that you would obtain substitute counsel within your firm. Okay, so U-Visa cases, for example, do take quite some time to be adjudicated. And so after that initial filing, the case is going to be pending for quite some time. It would be your responsibility to check in with the client every so often, just to make sure that there haven't been any major life events that would change their case, or if there's something like a change of address, then that you update USCIS. But otherwise, you're mostly just hanging out waiting for that case to be adjudicated, and then once it is, you'll communicate that with the client. It's important, though, for that consistency with you or someone else in your firm, because we don't have the capacity to take these cases back in-house. We do ask that you also provide for interpreters, whether that's in your client meeting or someone to translate documents that you're using in your case. If you need volunteers, you can reach out to us, but we do find that oftentimes firms can utilize support staff in other areas. Maybe somebody on your team speaks the foreign language that the client speaks and may be interested in helping out with the case. Of course, we ask, because we remain of counsel, we ask that you keep us informed on all updates of the case, including filing dates, any upcoming deadlines, any requests for evidence, and any communication with USCIS about the case. And then it's not just you and NIJC, but it's also the client who's a partner in this. And it's very important that the client remain in communication with you throughout the life of the case, and that they be truthful and open and honest with you about their life and what happened that makes them eligible for this form of relief. So that's a general overview of who does what. We want to make sure that you're very well prepared to prepare these cases. And so we offer sample briefs, case documents, manuals, appendices, frequently asked questions, policy updates. All of that can be found on NIJC's website. If you're looking for something specific and you can't find it then you can reach out to me or Liz or Jackie on our project, and we can point you in the right direction. So I'm going to go ahead. I don't see any questions so far. I'm going to go ahead and jump right in to talking about the U non-immigrant visa. So what is the U visa, and why are we here today? Well, the U visa was created to strengthen the ability of law enforcement agencies to be able to investigate and prosecute cases of domestic violence and other qualifying crimes. Okay, so it was created sort of as a win-win visa. We'll help you if you help us, right? So there are many reasons why oftentimes immigrants are afraid to report things to the police or assist in the investigation or prosecution of a crime. Well, this is a way that law enforcement is trying to improve the relationship with immigrant communities. It provides a mechanism also then for the client who's a victim of a crime to be able to remain in the United States in order to assist in that investigation or prosecution. This visa came out of the Victims of Trafficking and Violence Prevention Act back in 2000. It took about 8 years for USCIS to finally write the regulations, but since 2008, we've been able to help many people apply for U visas. The various components and actors involved would be the client and their family, you and us, pro bono attorney and NIJC, but also then the law enforcement agency and USCIS. So the application will be filed with USCIS, which is the arm of the Department of Justice that handles adjudicating these cases that are affirmatively filed. And then the reason the law enforcement agency is an actor is because in order to apply for a U visa, you need to get a certification signed by law enforcement. And we'll talk more about that a little bit further in the presentation. So why would someone want to apply for a U visa? Well, generally speaking, most of our U visa applicants have no immigration status here in the United States. And it's challenging to live here without status. And the U visa can provide a non-immigrant status and employment authorization for up to 4 years with possible extensions. And so what that means is when the case is adjudicated, if it's approved, the person will no longer be here without status, but they will actually have non-immigrant status. And with that comes an employment authorization. Okay, so they're able to work here lawfully. It also provides a path to citizenship. Once someone is granted a U visa, after they've been here for 3 years in U status, they're able to apply for their green card. So that's huge. It leads towards permanent residency and then eventually a path towards citizenship. Another huge benefit is you can include family members as derivatives on a U visa application. So for example, if I am over 21 years old and I'm applying for a U visa, I can include my spouse and unmarried children under 21 on that application as derivatives. If I'm under 21, I can also include my parents and siblings who are under age 18 on that application as derivatives. We'll go into more specifics about that later. Generally speaking, the derivative relationship must exist at the time that the principal files that I-18 application. There are some exceptions, okay? And so if you have questions about that, you can ask me after the fact. Now, lots of great benefits. There are some limitations, okay? So if I am the victim of a crime and the perpetrator of that crime is a relative of mine, I am prohibited from petitioning for that relative as a derivative on my application. So for example, if my spouse is the person who abused me and I'm eligible for a U visa based on domestic violence, I would not be able to petition for my spouse as a derivative if that's the person who made me eligible for a U visa, okay? There's also an annual cap of 10,000 U visas per fiscal year. So USCIS's fiscal year is October 1st to September 30th. So every year on October 1st, they have 10,000 new U visas that they can start issuing. But the reality is there are many, many more than 10,000, many more applicants each year that apply for U visas. In the early years of the U visa, there weren't, and so we didn't reach that cap immediately. But we have reached the cap consistently year after year for the past many years, probably close to 10 years. And there's now a huge backlog, which is part of the reason that the processing times are so long for the U visa. There have been some workarounds, and we'll get to those a little bit later. But generally speaking, the many benefits here outweigh the limitations for most of our clients, which makes it worthwhile for people to pursue the U visa. So derivatives, okay? If the principal applicant, the victim of the crime, is under 21 years old, they can petition for parents, siblings who are under 18 and unmarried, and then any spouse and children that they have who are unmarried and under 21. So if we think about this, say you have an applicant who was a victim of a crime, they're 20 years old, they're married and have a child. They could include their spouse and unmarried child who's under 21. They could also include their parents, and they could include any siblings that are under age 18. So that can be a lot of people who could benefit from this U visa. And I need to point out that that annual cap of 10,000 U visas only applies to principal applicants, right? So in this scenario that I just gave you, there could be 7 people who are applying as part of this one case, but there's only one principal applicant and the rest are derivatives. So only that principal applicant would count against those 10,000 U visas that are granted annually. On the other hand, if the victim of the crime is over 21 years old, then they can include their unmarried children who are under 21 at the time of filing and their spouse. Okay, so something to keep in mind here is there may be a deadline on the case that you're working on due to an age out factor, right? So if you are filing a U visa application for somebody who is over 21 and they want to include their unmarried child who's under 21, but the child is going to turn 21 next month, then you would want to try to file that application before the child turns 21 so that they can be included as a derivative. So with U visas, the standard of proof is any credible evidence. And you can find this in the Code of Federal Regulations at 8 CFR section 214.14. That's where all of the U visa regulations are. This is important because for many domestic violence survivors and possibly other qualifying criminal activity for the U visa, it's often difficult to gather primary evidence to support your case, okay? If you are a survivor of domestic violence and you're fleeing an abusive situation, you may not have time to gather all of the evidence that you want or need for your case. And so we will work with the clients to help make sure that they gather sufficient evidence for their case. But we also do point out to USCIS that the standard is any credible evidence because they shouldn't be asking for or requiring more than that. I see we do have a question here for the cap. Do people essentially just have to wait until something opens, or is there a lottery type of thing that happens each October? Great question. It is on first come, first served basis, essentially. And so U visas are issued in the order that they were received, the filing date for the U visa. And so you don't have to worry about a lottery. It doesn't go that way. Essentially, it goes in order of application. So for a client who applied in 2020, their case should be adjudicated before an applicant who applies in 2021 or 2022. The exception to that would be that if your case is issued a request for evidence, okay, an RFE, a request for evidence, then USCIS is requesting additional evidence on your case, and you would have to respond to that request for evidence in order for them to make a final adjudication on the case. So that could mean that while you are preparing that response, they continue down the line adjudicating other cases, right? So I can say that, you know, we've received cases for clients who filed their applications in 2016, but yet I might have 1 or 2 cases still from 2015 that aren't finalized because the client received a request for evidence. But generally speaking, they go in order of receipt. So who qualifies to apply for the U visa? Well, we're going to have to break down the various elements of eligibility, one of them being, what is the definition of a victim? Okay, so who qualifies as a victim for purposes of a U visa? Well, a direct victim is pretty self-explanatory. It's what we think of when we think of a victim of a crime. It's the person who is directly and proximately harmed by that qualifying criminal activity. So if somebody is shot, it's that person who would be the direct victim. However, we can also include bystander victims, okay? So this is rare, but it is possible where you could have somebody apply as a bystander, and that would be somebody who witnessed a violent crime and suffered an unusually direct injury. So the most common example of this is somebody that witnessed a crime and then suffered a miscarriage as a result of that. And so they still suffered an unusually direct injury as a result of witnessing that crime, being a bystander. Indirect victims, on the other hand, can also qualify as victims for purposes of the U visa. And that would be if the direct victim is murdered or incompetent or incapacitated, then the direct victim can include a spouse, children who are under 21, parents, if that direct victim is under 21, or siblings who are under age 18 if the direct victim is under 21. So if we think of this as an example, right, if the direct victim was murdered and over 21, then their spouse could apply for U visa as an indirect victim. Their children who are under 21 could also apply as indirect victims. What we see pretty commonly in our office is children who are victims of sexual abuse. The parents can apply as indirect victims because a child of a certain age could be considered incompetent based strictly on their age. Okay, there's a question here. What if USCIS has met the 10,000 quota for the year before my client becomes a victim of a crime? Does it mean that my client would be denied a U visa? No, not at all. So the 10,000 cap is only the amount of visas that they're allowed to give out each year, but there is no sort of statute of limitations for when you can apply for a U visa. So you can be the victim of a crime today, you could have been the victim of a crime 20 years ago, and you can still apply for that U visa today, and then your case will be adjudicated in the order that it was received. Okay, so when USCIS gets around to adjudicating the cases from February 2022, they will adjudicate your case at that time. If there's a visa available at that time, you will be granted one. If not, then your case will be included in the backlog, and we'll get to that a little bit later. So going back to indirect victims, I just want to mention this can also include victims of witness tampering, obstruction of justice, or perjury. And then there's also the definition of a next friend. This would be the person who sits in for somebody in court if they are incompetent or incapacitated. So principal applicants, once you've determined that your client is the victim of a qualifying crime, we'll get to the qualifying crimes in just a moment, what do they have to prove? Well, they have to prove not only that they've been a victim of the crime, but that they have suffered substantial mental or physical abuse as a result of that criminal activity, that they have been helpful, are being helpful, or are likely to be helpful in the federal, state, or local investigation or prosecution of the crime, that they possess information concerning that criminal activity, and that the crime occurred in the United States or violated US law. Now, all of this can be found in the INA, the Immigration and Nationality Act, at section 101A15U, and again at the Code of Federal Regulations, 8 CFR 214.14. So here's the list of criminal activity. Okay, it's a pretty long list and rather extensive. It also includes any similar activity in violation of US federal, state, or local law. Okay, and that's important because on this list, there aren't laws related to each of these crimes in every jurisdiction. Okay, so what may be considered extortion at the federal level, maybe the local jurisdiction does not have a criminal statute regarding extortion. But if your client was the victim of a similar crime and you can make the legal argument of why that is substantially similar to the federal definition of extortion and why your client was a victim of that, then they should be eligible for a U visa. It also includes attempts, conspiracy, or solicitation to commit any of the crimes in this list. So attempted murder would qualify, right? Attempted sexual abuse qualifies. Any questions? Not seeing any right now. Please feel free to put more questions in the chat as they come up. I know this is a lot of information. So talking a little bit more specifically about the different elements that we have to prove. Substantial physical or mental abuse. No single factor is a prerequisite. And this is important because if you take a crime like domestic violence into consideration, there could be not just one incident that makes someone eligible for a U visa. For example, we often, after talking to our clients who are survivors of domestic violence, learn that there were years that built up this domestic violence relationship, right? It could be mental and emotional abuse or verbal abuse, and maybe they didn't recognize that it was physical abuse at first or that it was domestic violence at first, but it was the years of humiliation and losing of self-confidence that contributed to the nature of this relationship and the power and control that the abuser had in the relationship. And so maybe the one time that they called the police doesn't seem like it's as big of a, or as impactful of an incident, but you can take into consideration the many years of abuse that the person has suffered. So USCIS will consider the nature of injury inflicted, the severity of the perpetrator's conduct, the severity of harm suffered, and the duration of the infliction of the harm, right? So if this has been years in the making, that is taken into consideration. There is a definition from the Code of Federal Regulations of physical or mental abuse. It's defined as injury or harm to the victim's physical person, or harm or impairment of the emotional or psychological soundness of the victim. Next, once we've determined that our client was in fact a victim of a qualifying crime and they meet the definition of a victim, how do we prove that they have cooperated with law enforcement? Well, this piece is really essential. They need to obtain the U visa certification form. It's Form I-918 Supplement B. You'll see there in the yellow box. It's the form that they need to have signed by either the law enforcement agency that investigated the crime, or if there was a prosecution, the agency that prosecuted the crime, or a judge who was involved in the investigation or prosecution of the case, okay? Assisting law enforcement in either the investigation or prosecution of the crime is necessary for a U visa. For applicants who are under age 16 or incompetent or incapacitated, then it can be the parent, guardian, or next friend who provides that cooperation with law enforcement. And there is an ongoing responsibility on behalf of the victim to continue cooperating. Of course, one requirement is that the victim possesses information regarding the crime. They must have knowledge of the details of the qualifying criminal activity in order to assist in the investigation or prosecution. Now, there's not a requirement of a certain amount of information, right? So I've had clients who were knocked out, who were unconscious as a result of the crime that they were victim to, and they're still eligible for a U visa, and they've still been granted U visas. It's a matter of them cooperating with law enforcement with the information that they have. So here's that I-918 Supplement B. You can kind of see it over there on the right. You must include the original signed certification. You can't include a copy, and it must be signed within 6 months before you file the application. So in other words, the certification will expire 6 months after it was signed. And USCIS is very strict on that 6-month requirement. So if the certification was signed on February 15th, last week, then by August 15th, it will be expired. So that certification and that U visa application would need to be filed by August 14th in order for it to be considered valid. The certification needs to be signed and completed by the head of the certifying agency or someone who is specifically designated by the head of the agency to sign a certification, or a federal, state, or local judge. So in other words, here in Chicago, the Chicago Police Department has the records department, and the sergeants in the records department are in charge of signing U visa certifications because they have been designated by the chief of police. However, in a lot of the smaller jurisdictions that we work with, it is going to be the head of the certifying agency who actually signs the certification. If you or your client obtains a certification signed by someone other than the head of the agency, then you would need to get a letter from the head of the agency designating that person as an official certifier. The U visa certification form is essential. Without it, you cannot apply for a U visa, but it is not conclusive evidence of any of the eligibility requirements, meaning they still need to prove everything else. Finally, an applicant must prove that they are admissible. So inadmissibility is an immigration term that is used to describe one of the many reasons that a person might not be eligible to obtain a visa or a green card. Okay. Fortunately, for U visa applicants, if you are inadmissible, you are most likely eligible for a waiver. Okay. There is a waiver of inadmissibility that is available to U visa applicants that is extremely generous, and U visa applicants can waive most grounds of inadmissibility. So the common grounds of inadmissibility that we see are here in the box, such as entry without inspection. So somebody that entered the United States without permission, previous unlawful presence here in the United States, or a prior deportation, fraud or willful misrepresentation, right? Maybe they used a fake visa or green card to enter the United States, or maybe they made a false claim to US citizenship, or maybe they brought their children here illegally, or which would be smuggling. All of those things, all of those grounds of inadmissibility can be waived for the U visa. That waiver is on Form I-192. Okay, that's the waiver for non-immigrant visas. So those of you that practice immigration law might be familiar with an I-601 waiver, which would be a waiver, for example, for a family-based immigration case, or an I-602 waiver, which would be for a refugee. This is an I-192 waiver for a non-immigrant visa. And the requirement is that you demonstrate that it is in the national or public interest for the waiver to be granted. That's very vague, it's very general. USCIS will consider a number of things. They'll consider evidence of rehabilitation. So if your inadmissibility ground, for example, was criminal activity, then you would want to show that your client rehabilitated and is no longer committing those crimes. Reasons for wishing to remain in the United States and any mitigating factors in the client's favor. So why should the US government grant this waiver? Why should they want this client to be here, right? So any positive discretionary evidence that you can include about why it's a good idea for your client to be here in the national and public interest, and also anything good that they're contributing to the community. So the applicant does need to include an affidavit explaining all of the admissibility grounds that apply to their case and why it is in the national or public interest for that waiver to be granted. They can also include information about any loss of access to either the criminal justice system or other social services and mental and medical services that they receive here but would not be available in their home country. The waiver does have a filing fee associated with it. Okay, so the U visa application is on Form I-918. The I-918 does not have a filing fee. So it's free. Someone can apply for a U visa with no fee to the government. However, the inadmissibility waiver, which most of our clients do need, does have a fee associated with it of $930. The good thing is that most of our clients are low income and do qualify for a waiver, a fee waiver for that I-192 fee. So if you're taking out a case from NIJC, we'll walk you through whether the client is eligible for a fee waiver and under what grounds. The confidentiality provisions under Section 384 of the Illegal Immigration Reform and Immigrant Responsibility Act, IRA, do apply to U visa applicant. These confidentiality provisions prohibit the Department of Homeland Security and the Department of Justice from providing any information about a U visa applicant to a third party. So that would include family members, friends, the abuser or perpetrator of a crime. And that's important because a lot of our clients who have been victims of crime or domestic violence are afraid of retaliation. They're afraid that the abuser could find out and then things could get worse. And so it's important to explain this to your client, make sure that they understand that there are confidentiality provisions that prohibit the government from sharing any information about their case. And the only way that the perpetrator would learn about them applying for a U visa is if the client themselves told them. Because of course you have attorney-client confidentiality and you're not allowed to share that information either. And I usually explain to the clients and discourage them from sharing that information with the perpetrator because it could harm them in the long run. Similarly, the confidentiality provisions prohibit the Department of Homeland Security from making any decisions about the removability of an applicant based solely on information provided by the abuser. So real briefly, I think I have 1 minute before it's Liz's turn. We'll go over this case example here. Ana is a Mexican citizen who entered the United States without inspection in 2010 with her 1-year-old child. In 2012, she married Juan, who is undocumented, and the couple later had 2 U.S. citizen children. During the marriage, Juan did not let Ana leave the house without his permission. He controlled all the money and often threatened to have her deported. On one occasion, he repeatedly hit her and she called the police. He fled before the police arrived. She did file a police report, but he was never arrested. Thereafter, she took the children to a domestic violence shelter and obtained a civil order protection. She's seeking a divorce, and Juan continues to call her and threaten her. So, a raise of hands, if you feel like it. Who thinks that Ana could be eligible for a U visa? Okay, I'm seeing some hands raised. Definitely, yes, Ana could be eligible for a U visa. She has been the victim of a qualifying crime of domestic violence, and she reported it to the police, so she did cooperate. She filed a police report. It doesn't matter that he was not arrested. It's investigation or prosecution of the crime. So as long as she assisted in either the investigation or prosecution, then she can be eligible for a U visa. Of course, she is going to have to obtain that certification from law enforcement. She'll have to prove that she was a victim of the crime and show that she suffered substantial harm. So we could use evidence like her order of protection and any information from the domestic violence shelter that she can obtain. Does anybody think that she would need a waiver of inadmissibility? Hands? Yeah, yes, so she will need a waiver of inadmissibility. Let me just, sorry, I'm trying to multitask here and look at the questions. So she entered the country without inspection, so she would need a waiver of inadmissibility for that. And she didn't bring any children with her, right? Oh yes, she did, sorry, with her 1-year-old child back in 2010. So that child would have been born in 2009, was 1 year old at the time, so that would be smuggling. That child, now we're in 2022, is 12 or 13 years old. So would that child qualify as a derivative? Hopefully. And I'm just realizing, you know, I had created these polls to have you all participate and I completely forgot about them. So we are going to skip the polls. Sorry, Liz, but it's your turn. So I'm going to go ahead and let Liz take over from here.
Hey, Trisha, it's okay. We can do them later if we have time. If not, that's fine. All right, so we're going to talk about now working with survivors of domestic violence. So as Trisha already reviewed, right, people seeking protection under the U visa have been victims of violent crimes. Some of these qualifying crimes vary, as was shown in the long list earlier. However, most of U visa clients that we see here in our office have dealt with gender-based violence, such as domestic violence and sexual assault, which is why we will be focusing on these, especially domestic violence. And so this means that there is a significant amount of trauma involved in these cases, and we'll go over some best practices and information throughout this presentation that will be useful, hopefully, to keep in mind when working with your clients who have survived these crimes. And so since we're discussing domestic violence, I always think it's super important to first define it, right? So domestic violence can be defined as a pattern of physical and psychological abuse used by one person to exert power and control over another person in the context either of dating, family, or household relationship. And so throughout this presentation, I'll mostly be referencing to relationship abuse because this is what we often see in domestic violence-based cases that we work with. And so some of the tactics used by someone who is abusive in an abusive relationship can be referenced in the power and control wheel that you see here in front of you. So both sexual assault and domestic violence are about power and control. A partner who is abusive will assert their power and control in physical and non-physical forms. And we like to reference to this wheel to show the overall pattern of abuse and violence used by someone who is abusive, because it shows how someone can maintain control, right? And how some of these methods are very specific to the immigrant population. And some of the things that are commonly heard when talking about domestic violence in regards to physical abuse, there's also threats, especially when threatening to take the children away, for example, threatening to call immigration if they're undocumented. However, there are so many other ways that a person who is abusive may exert that power and control over someone without leaving any type of physical injury. And so in a lot of cases, there might not be any physical violence at all, actually, and that does not make things less abusive. Just harder to catch right away and prove, unfortunately. And so some of these include abuse through economic means, isolation, emotional, psychological, and sexual abuse. And here we show some very specific, scenarios of how these can show up. We've heard many times how survivors of domestic violence felt trapped in their abusive relationship because their spouse or their partner controlled all the money. And a large number of abusive partners also bring the violence into the workplace by stalking, by checking up on them constantly through the phone, text, getting to the point of threatening them and their workmates. And in these examples, an abusive partner is basically trying to break their partner's attachment to their job, get them fired, or get them to quit so that they're more dependent on them. We also often hear about how the survivor had to endure not being able to see their family or friends because their partner would not allow it, or they would get very jealous, right? And so an example of a red flag would be when an abuser tells their partner that their friends aren't allowed to be with them unless they're present. And when an abuser isolates someone from their friends and family, they're not only trying to make it easier for them to be manipulative, but it also creates, again, that dependency on the abusive partner for support. Other acts of abuse include emotional and psychological. So that could be insults, humiliating them at home or in public by calling them names, putting them down, An abusive partner could threaten to commit suicide. A related tactic used is minimizing. So minimizing can be defined as when someone is causing another person to self-doubt by downplaying what happened. And this often occurs when someone manipulates you into feeling like you're being irrational, for example. And lastly, I'd like to touch on sexual abuse because this is something that happens more often than we hear in relationship abuse. And sometimes there's a lot of shame that comes with talking about this. Oftentimes, abusive partners who are physically violent are often sexually abusive as well. Sexual abuse can range from calling the partner experiencing abuse, degrading sexual names, constantly pressuring them to have sex when they don't want to, becoming angry or violent when they refuse sex, intentionally passing on sexually transmitted diseases, and many other ways that that can come up. And so these are all means to assert, again, power and control in the relationship. And so those were just some examples of the different tactics of abuse, but there are many more highlighted on this power and control wheel. But now let's talk about the cycle of abuse. This is something we need to keep in mind because we commonly see this when working with survivors of domestic violence. We may ask a survivor how the relationship was in the beginning, because oftentimes relationships start with a lot of love, a lot of kindness, which is also known as the honeymoon phase. But this phase might not last very long. We often see it move into the tension building phase, where there might not be physical violence yet, but the abuser may slowly start isolating their partner, start controlling the financials, for example. Oftentimes, this tension building phase can lead to an explosion where physical violence can occur. It's not always the case, though. Remember that physical violence is not always present. And after an explosion, the abuser might try to patch things up by asking for forgiveness, by blaming their partner for what happened, and maybe try to be romantic, right? So this might work because the one experiencing the abuse believes them and may want to give them another chance. And so the violence is then repeated through this cycle, and what ends up happening is that that honeymoon phase slowly starts disappearing over time, and there might be a lot of denial, a lot of self-blame. And I'd like to point out that it's not in every case that there's this continuous victimization over many years, but it is something that we do see a lot. And so some of our clients have been able to leave their abusive partner. They might live in a domestic violence shelter or with family or friends. Others may continue to live with their abusive partners throughout the process of applying for immigration relief, particularly where there are children involved. And so everyone's situation will be very different, but it's helpful to keep these things in mind in order to best provide the best possible representation as a pro bono attorney. And lastly, people may wonder why someone wouldn't just leave an abusive relationship. And so leaving is often the most dangerous time for someone who has been abused, because when a victim leaves, they are taking control and threatening the abuser's power, which could cause the abuser to retaliate in very destructive ways. Leaving could sometimes mean death to the victim, and that's why it's important from refraining from giving your opinion to someone who is experiencing domestic violence, because who better knows their abuser other than the person living with them and experiencing the abuse. So just things to keep in mind. Okay, next, please. All right, so at NIJC, our clients come from a wide range of different cultural, religious, and socioeconomic backgrounds. The immigration communities that we serve face many challenges, and with respect to not only their immigration status, but also other barriers when it comes to trying to access help and resources to break that cycle of abuse. And so some of these barriers include, but are not limited to, language limitations, extreme isolation, so feeling like they are alone and that no one might understand, cultural ideas of family shame and honor that can stem from their home country and trying to adapt to a new culture and systems in the US. This can also be linked to how domestic violence or relationship abuse is a topic that's oftentimes taboo. There's also the barrier of having close-knit communities, which can be an asset, right? But it's also true that it can sometimes make it difficult for people to seek help if they're experiencing abuse. So for example, it might be that in someone's community, it's frowned upon to have outside interference when it comes to domestic violence, and a belief that the family is the only appropriate forum for dealing with these issues. In some instances, outside interference isn't encouraged or accepted. And it's important to note that there's also a general mistrust with law enforcement agencies, right? Also medical and criminal justice systems, especially in immigrant communities, because they've been failed oftentimes by these systems. And there's also the role of religion, which it can also be a huge asset to folks that are experiencing abuse. But on the other hand, it can also be a barrier sometimes, because it can make it difficult for folks in these communities to seek help, since they're severely stigmatized, for example, if they divorce, right? Or if they get help from, someplace else that's not in their community. And so while these cultural differences must be considered, assumptions should never be made about someone's culture, because domestic violence is not unique to any particular community, race, or culture. There's also this common misconception that domestic violence happens more often in immigrant communities, and it's certainly not true. Domestic violence is an issue that exists amongst all races, genders, sexual orientations, socioeconomic status, etc. And so cisgendered men, for example, can face domestic abuse, and abuse can also exist in non-heterosexual relationships. And so the reason why we might not hear about it as often is due to underreporting. And there's many reasons why people experiencing abuse might not speak out or seek help. Okay, next slide. And so we touched on this a little bit earlier, but I do want to make sure that we emphasize that a huge way in which the method of control and power comes up in a relationship is when someone's fear related to their immigration status is used against them to intimidate them, keep them from speaking out. And we've seen situations of manipulation where an abuser might file an I-130 family-based petition or any other type of application and later withdraws it. Or they threaten to tell immigration that they're a fraud and only got married to them for a green card. And all of these tactics of abuse and the cycle of abuse are good to keep in mind, because there's many things that need to be unpacked, right? This is also why we always encourage clients, if they haven't already, to try counseling so that they not only continue their journey of healing, but also get a letter of support from their counselor where they identify the different types of abuse that the client might have experienced. Okay. Next slide. Okay, so we'd like to take a small break here and be back in 10 minutes, right? So it's 1:56. Can we be back at 2:05?
That sounds good to me.
Yeah.
And if you have questions, please feel free to put those in the chat and we'll do our best to answer them.
Thank you, everybody.
Okay, and we're back. So before we jump into preparing a U visa case, I did want to address one of the questions that came up. Thank you all for your questions. I'm doing my best to answer them as we go. But somebody did ask specifically about the after acquired spouse. And I did mention that derivatives can be derivatives because the relationship occurs after the filing of that initial I-918 application. So initially, when the U visa came about, the regulations said that the relationship had to exist at the time of filing the principal U visa application. So in other words, if I am filing a U visa application and I'm filing that form I-918, then the only people that I could include as derivatives would be my qualifying relatives at the time that I filed my I-918 application. Well, there was recently a case called Medina Tovar out of the Ninth Circuit that actually found that an after acquired spouse could qualify as a derivative spouse for purposes of the U visa. In other words, during the duration of the U visa application, the applicant got married and wanted to include her spouse as a derivative applicant on her U visa application, and the Ninth Circuit found that he was eligible. And so just recently, within the past year, I believe, USCIS has decided to apply that throughout the country. And so now if you have a U visa applicant who gets married while they're waiting for their U visa application to be adjudicated, they could in fact include that derivative as a derivative on the application as an after acquired spouse based on Medina Tovar. And so in the questions, in my answers, I did add that practice advisory that was created by Assista and ILRC and Clinic. And so I hope that that is helpful, and I hope that you can all see that in the questions. If not, I'm going to actually try to put it in the chat too, just to make sure that y'all have it. And I think that that's it for questions here right now. So take it away, Liz.
Okay. All right, everyone. It's Friday, so hopefully we can get through with this sooner. But if not, well, we have 2 hours, right? So we're almost done. I'll now be talking about how to prepare a U visa case. So we'll review how to get started, how to conduct client meetings, what case evidence can be used. It's a lot of text in these slides, and the reason for that is because we hope that you can use these slides as a reference in your future casework. So if there's any questions, anything we might have missed, just again, feel free to ask away in the chat or reach out afterwards. After the presentation, we'll be including our emails, our phone numbers. All right, so let's start with connecting with clients, because from the beginning, it's important to create that relationship with your client, create that safe space where your client feels safe. This might look different now that we're working remotely. And on our website, we do have some great resources on best practices for attorneys working remotely during the pandemic. And we will send these resources as a follow-up email after our training, and they're also attached to the training as well. And so typically for your first meeting, it's always a good idea to explain your relationship with NIJC, although we do explain this when we sign that pro bono retainer. It's still important to reiterate this because by this point, the client has already received so much information, and we want to make sure that everyone's on the same page and that there's no confusion. It's always good to keep in mind that speaking simply on a one-to-one level instead of talking with like legal terms, it's a good way to communicate like that with your client. If you need an interpreter, that's also something that you should secure before you meet with them for the first time. And we will let you know also if the client might be needing an interpreter if they don't speak English, right? So stressing confidentiality is something else that's extremely important when trying to build that rapport. Explain that you will not be sharing their information with anybody else unless they grant you permission to do so with the release of information. So this can be, for example, when you need to speak to their counselor to get an updated letter of support from them. A lot of people can have anxiety about their abusive partner or their family finding out about the case. So stressing that this is safe, confidential, and creating that space for them will be very beneficial. Additionally, setting up a good communication plan is crucial, especially for individuals that are living in shelters or in unsafe situations at home. Ask them what their preferred method of communication is. And we always make sure to flag if someone's home address is not safe, but a client might move around or circumstances may change. So it's good to just check up on that every time that you can. And if the client is living with their abusive partner, their phone could potentially be monitored and they might not be able to receive mail in fear that the abuser could see it, or text messages or phone calls, right? So keep that in mind. It's good practice to ask things like, is it safe for me to leave a voice message at this number? Do you have a preferred address or has it changed? And furthermore, explaining the process is important in building that relationship of trust so that the client understands how long processing times are for U visa cases and when they might be getting a work permit. Understand what are the different fees, waivers, what documents they need to bring to you. And so during our own screening process, we get the certification for you. We put together a referral packet with all the documents that the client has to start their case, but it's always a good idea to review everything closely with the client to see if there's any more pieces of evidence that can be included or excluded to strengthen their case. And we do have a sample list of documents in our manual appendices and numerous other resources on our website with all of this information. And something that might come up before going on to the next slide is that the client might ask you questions that are beyond the scope of the case. So for example, they might ask about counseling, tax assistance, especially right now, right? Other services that they need. And so we do not expect you as a pro bono attorney to answer all of these questions because it is beyond the scope of the case. And what you can do is just reach out to us. And we have many great referral options on our website. And also if you reach out directly, we can provide those for you. Okay, next. All right, so Tricia already touched on this briefly, but it's important to make sure that you have the original U visa certification, right? And it's best to make sure that during your first meeting, you collect this. We recommend that you get to know your client's story. This is part of the relationship building, trust building with your client. Begin filling out application forms, give the client a list of additional documents they need to bring, and schedule that next meeting. We recommend that in the next meetings you begin working on that affidavit. It's typically, not one meeting where you get to finish off an affidavit. You might need 2 or 3 or more, depending on the case. And we recommend that you wait until you've had a couple of meetings with your client before starting on that, just so that you have some time to build that relationship and that safe space. But this is all on a case-by-case basis. You should gauge your client's comfort level. For example, you might have someone who was a victim of felonious assault, and the incident might have happened several years ago. And maybe by this time, they've moved through it, they've gotten counseling, and they're ready to work on that affidavit off the bat. It's good to just be aware that not every person will be ready to share their story with you right away. And this is also very difficult when you think about having to use an interpreter, right? So keep that in mind. And some might immediately open up, others might not. That's okay. And what we like to do in our referral packets is share with you our internal case notes from our legal screening so that you do have a basic understanding of who this person is, who their family members are, what they've gone through in relation to their case, and anything else that's important to know. So you should definitely confirm all of that with your client, take a look at it before your meeting, and reach out if you have any questions. And if working on a case involving domestic violence, use that power and control wheel. Feel free to use that. We have that power and control wheel in English and Spanish, and if you need another language, that can also be found online if you just Google it. And so when your client opens up to you about these traumatic events in their life and the details regarding the crime, you should actively listen, right? Be non-judgmental, be as empathetic as possible, and validate their decision to disclose, the difficulty of that vulnerability. Some of the ways you can do this is by saying things like, "Thank you for having the courage to share that. Your feelings are completely valid. Oh, I get why you feel that way," right? So some of these things can go a long way. If someone is still living in an abusive situation, it might help to ask, what do you need right now? Is there anything that I can do to support you? Never ask questions beginning with why or questions that are leading questions. So leading questions are questions that lead the client to answer the way that you want them to. Remember that their affidavit needs to be in the client's voice, right? And so it's more appropriate to ask open-ended questions. For example, use how and what questions. For example, how did you feel when they said that to you, right? So things to keep in mind. And we can go on to the next slide. Yes, evidence. Okay. So for evidence, each principal and derivative applicant must have their own complete application packet. So that includes cover letter, forms, identity documents, and supporting documents, and the affidavits. Make sure that the affidavit is in the applicant's own words, like I said earlier. So the client can write their own affidavit in their native language and then have a certified translation of it. However, what we have found is that the best affidavits are the ones where you sit down with the client one-on-one and draft something together. Some key things that the affidavit should address for the principal applicant are basic biographic information, substantial physical or mental abuse, knowledge and information about the crime, how they were helpful in the investigation or prosecution of the crime, and reasons why the granting of their U visa and waiver, if they're going to be submitting that, is in the national and public interest to be granted. And for principal and derivatives, identity documents are needed, right? So passports, birth certificates. For principal applicants, U visa eligibility supporting documents are required to prove they've been a victim of the qualifying crime, that they've suffered substantial harm and cooperated with law enforcement. And if they require a waiver of inadmissibility, they will need to include supporting documents to demonstrate to the government that they merit that waiver in the exercise of discretion. Okay, we can move on, but are there any questions actually, Trisha, before we move on?
No questions so far.
Okay. All right, so filing procedures. These are things that you'll need to file with your application packets for both principal and each derivative applicant. We'll go into more detail on the next slides. Okay. So for the principal application packet, again, you'll need that cover letter with an index of documents and the following forms that you see listed. So the G28 is a notice of entry of appearance as the attorney or accredited rep. The form I-918 is the National Immigrant Status petition. You'll need that original U visa certification form, which would be on the I-918 supplement B. And then form I-192 is the application for advance permission to enter as non-immigrant, also known as that inadmissibility waiver. And an I-765 form is the work permit application, and you'll need to include 2 passport style photos with that. You'll also need to include the correct fees for the waiver and for the work permit, or request a fee waiver using the form I-912 and include supporting documents for that. More information on the fee waiver will be discussed later. We also list here some supporting documents that you should include, but please refer back to our U-Visa manual and appendices for more details. Okay, next. And so for the derivatives application packet, you'll also need that cover letter, an index, and the following forms. Note that you should be including two G28s in this packet. So one would be for the petitioner, which is the principal, and another one for the beneficiary, which is a derivative applicant. Also note that instead of filing Form I-918, you'll be submitting the I-918 Supplement A, which is the derivative U-Visa application. And if the derivative is living in the US, you can also include that work permit application. For the derivative supporting documents, note that you will need to prove the qualifying relationship of the derivative to the principal. So this can be either a birth certificate for children or a marriage certificate for a spouse. And I'd also like to point out that there are two work permit applications listed here. So one would be for category A20 and another for category C14. I'll go into more detail about this in our next slides. Okay, next. So in terms of employment authorization, USCIS will automatically issue an initial work permit with category A19 when granting the U-Visa for the principal applicant. So this work permit would be valid for 4 years. However, for derivatives, they will not get an automatic work permit when their U-Visa is granted. This means that as soon as their I-918 Supplement A gets approved, you will need to file the Form I-765 under category A20 if it was not filed initially with the application. And as you can see here, there are various categories for employment authorization. We've included here a summarized list. And due to that cap of 10,000, if we could just go back, thank you, of U-Visas per fiscal year, there's obviously a huge backlog, right? And USCIS might issue a bona fide determination, also known as a BFD, or a waitlist notice. Both of these will grant the applicant deferred action if they're living in the US and make them eligible for a work permit while they wait for a final decision on their case. So more information on the BFD in a second, and all of these work permits will be under category C14. Okay, next. And so filing fees, each form except for the I-918 and the I-918A is usually accompanied by a filing fee. All the fees should be paid in the form of a money order payable to the US Department of Homeland Security. We've included the filings here for each form, but they are subject to change. So keep that in mind. It's always good to check the USCIS website to confirm what the current fee is before you submit the application. Next. To request a fee waiver, you do need to submit the Form I-912 for each application packet. USCIS will approve a fee waiver based on their discretion for applicants who can provide proof for one or more of the following listed here. So if they receive a means-tested benefit, if they have a household income of 150% or below of the poverty guidelines, or if they can demonstrate financial hardship. So you should gather documents to prove one or more of these qualifications. Some evidence can include a letter that says the amount of food stamps that they receive, any other public benefit, transcript of federal income tax returns, pay stubs, utility bills, rent receipts, etc. It's important to include as many supporting documents for this fee waiver request because it has become increasingly difficult to receive a fee waiver with the Vermont Service Center. And if the fee waiver does get denied, the waiver of inadmissibility and the work authorization application does get rejected and it will be sent back to you. And what you'll need to do is basically refile that with more evidence or submit, the fees. Okay, next. So here are some filing tips. Always include the certified translation of any foreign document. In our manual, we do provide various translation templates for you to use. For all USCIS forms, confirm that you are using the most recent and currently accepted version of the forms, because USCIS does update the forms very regularly. Some other logistical tips: application packets should be 2-hole punched at the top, binded with metal prong fasteners or a binder clip. Never use spiral binding. Do not use tabs or other exhibit markers. We recommend just use page numbers. You'll need to prepare separate application packets for the principal and a separate one for derivatives. And when you're ready to file the application, you can place all of the packets into one mailing envelope, send it through FedEx or any other trackable delivery service, and then keep a digital copy, okay, so that you can send it to us once you've sent it. Okay, next. And where to file. So we've included here the address where you will be mailing the application, which is the Vermont Service Center. Do note that the address has changed. So this is currently the address that you should be mailing it to. Make sure that you're mailing it to the correct one. Okay, so what happens next? Any questions before going to this section?
No questions. So
Okay.
if anybody has any, don't be shy.
Okay. All right. So what happens next, right? About 4 to 8 weeks after filing the U visa, you should be receiving a receipt notice where it says that USCIS received the application. Then you'll receive a biometrics appointment notice for the principal as well as the derivative soon after. And applicants need to attend their biometrics appointment or their application will be considered abandoned if they don't go. So they will need to bring their original biometrics appointment notice and a government issued photo ID. For clients with derivatives outside of the US, NIJC can guide you through this process, so just reach out. And so after the biometrics appointment has been attended, it will be a very long wait, right, for USCIS to review the application, make a decision because of that annual 10,000 cap. And so currently USCIS is looking at U visa applications filed in 2016. And I just heard that also early in 2017. And so what could happen before a final decision is made on the application is that USCIS can issue a request for evidence. If this happens, please contact NIJC immediately so that we can advise and guide you. And it's important to note too, that all immigration notices will only be sent to the attorney of record. So we ask that you provide us a copy of anything that was filed and received, and also provide any notices to your client. Now moving on to U visa bona fide determinations. As mentioned, before USCIS makes a final decision on a U visa case, they might issue a BFD or a waitlist determination. For the BFD, the Department of Homeland Security will decide if a U visa application is bona fide if in an initial review of the U visa application, they demonstrate that the application was complete and properly filed and a criminal background check does not raise any national security, public safety, or other concerns. And if DHS decides a U visa application is bona fide, the applicant will be granted deferred action and will be eligible for a work permit valid for 4 years, which can be renewed if necessary. And so if an application for an EAD was included with the initial U visa application, DHS will issue this EAD for 4 years. And if no EAD was filed initially, that's fine. What you will need to do then is submit that. And currently there is no fee required for that initial EAD under the bona fide determination, but a fee will be required for renewals. Now, if no bona fide determination is made, the U visa does remain pending and DHS will consider the application for the waitlist. If the case is placed on the waitlist, the applicant will be granted deferred action and an EAD. And at this point, it's unclear how long it will take DHS to make that BFD on a case. DHS has not explained the order in which it will review the cases, but given the hundreds of thousands of pending cases right now, you should not expect actually a quick action on the case. So this is something that you should be explaining to the client so that you can manage those expectations, because this is one of the things that we often get asked, right? The EAD is one of the most important things for someone. And so what we do know is that the BFD will come before the waitlist decision, which currently the waitlist has been taking about 5 years at the moment.
Liz, I wanted to jump in, sorry, with one answer to a question. So if the fee waiver is denied, okay, so if you're filing a fee for the I-192 waiver of inadmissibility or for the work permit applications, and that fee waiver request is denied, there is no expectation that you as the preparer, if you're a volunteer attorney or a staff member, there's no expectation that you would ever pay those filing fees, okay? We discussed that with the clients up front, that is their responsibility. Of course, you know, if the client qualifies for a fee waiver, you can, and it's denied, you can file a new fee waiver request. You just might need additional documentation. Some clients qualify for fee waivers requests and they still decide to pay the fee. That's also up to the client to decide, but it is never an expectation that you would take on any responsibility for any payments related to the filing fees.
Right. Thank you. Thank you, Trisha. Okay, so we can move on to the next slide. And so here we have a little more information on that bona fide determination, right, that I already explained. I think that it's important to note that one of the key differences between the bona fide determination and the waitlist are the standards. So remember that DHS can make a bona fide determination if an initial review of the U visa application demonstrates that the application was complete, properly filed, criminal background check looks good, right? And so to place someone on the U visa wait list, DHS must determine that the U visa application is approvable because the application meets all of the U visa eligibility requirements. And so the waitlist was created due to that annual 10,000 U visa cap initially. Right, and so important to note too that while deferred action is not a legal status, it does offer protection against deportation. Okay, and so here we just go over that. We do ask that pro bono attorneys agree to stay with the case until the client has been granted a U visa. However, we do understand that the adjudication process is very lengthy. And so we do offer the option of transferring the case back to NIJC once it's placed on the wait list and granted deferred action. We can move on. So keeping in touch with your client, I feel like this might be one of the hardest things to do, right? It's such a long waiting time, and we understand that. But it is important to keep in touch with your client. We recommend you check in with them every 6 months or so. You can set up calendar reminders if that's, helpful. Clients should also notify you if they get divorced, get arrested, and if they're planning on moving. If the client does move to a new address, the law requires that immigration is notified in writing. So you will need to file a change of address with Vermont. And you can see the special instructions on the USCIS website for more info, and also notify us so that we're aware and we keep track of that. And also, if your address as the attorney of record changes, you definitely should be notifying both immigration and us, because as I mentioned, all notices arrive only to the attorney of record. The client will never be receiving anything directly. Due to confidentiality, due to all those protections that Trisha talked about earlier. So it's important that Vermont has your current address. And next. And so the U visa approval, once that does happen, super exciting. You should be receiving approval notices of all the forms filed, but keep in mind that notices may arrive separately. Notify us when you receive any notices. And if a client has questions about travel or if a derivative is outside of the US, you can refer those questions to us. And after 3 years of having a U visa, clients are eligible to get their green card, also known as adjusting status. If a client contacts you about this, please refer them back to NIJC for a legal screening. We can certainly help them with that. It's important that they apply for adjustment before their U visa expires, or they can lose that eligibility. They can also lose eligibility if they travel outside of the US while they have U non-immigrant status. And here we list some references from all the sources that we use throughout this presentation, and some referrals as well. So we can continue to the next slide.
Sure, I want to just jump in here with a question. So Elizabeth asks, what if the I-918 certification was properly filled out and signed, but it says the victim did not cooperate with the police? And this is a very good question because, you know, if we go back to one of the slides before, it said, read that I-918 supplement B very carefully, right? So don't just assume that because you obtained that certification or because your client obtained a certification from law enforcement, that that's good enough. You need to review that certification very carefully to make sure that there is no damaging information certification. And so if I had a client with a certification that says they did not cooperate with the police, I would want to ask my client about that and then try to get some clarifying information, and then probably go back to that certifier and ask if they could amend the certification if that's appropriate. And what I mean by that is, for example, we have seen on occasion that a police report might say that the officer or the detective attempted to reach the victim and was not successful. And then the client will clarify with us, well, my abusive spouse damaged my cell phone. I had no phone. I had no way for the officer to reach me, right? And so if we can explain that to the officer, a lack of communication or a lack of follow-up isn't the same as a refusal to cooperate. And the regulations actually specify that it has to be a reasonable request, okay? And so as long as the client didn't unreasonably refuse to cooperate, then they can prove that they're still eligible. And so it is possible to make those arguments to USCIS, but it's also preferable to not have damaging or negative information in the certification. So my first thought would be to try to get that certification amended by the law enforcement agency, or if that's not possible, see if there's another agency that investigated or prosecuted the crime who would be willing to sign a certification without negative language. And then if neither of those things are successful, I would explain to the client that we can still file this U visa with this certification, but it is possible that USCIS is going to hone in on that and look for proof that you did not unreasonably refuse to cooperate. And so it could be an uphill battle, but ultimately it would be the client's decision if they want to go forward. Liz, do you have anything to add to that?
Just that, you know, when we do our legal screening, before we refer the case to a pro bono attorney, we try to catch those things. And if we can't do it due to timing, we let you know so that you're aware and guide you through that process. But yes, I mean, everything that Trisha mentioned is pretty on point. Yeah.
There's a follow-up or a separate question, but related. What if the victim reported the crime, but the police failed to investigate and the police report indicates that they did not review the videos that prove an attempted kidnapping or the assault on a victim, even when the victim presented the proof? How do I address the lack of investigation? This is a good one because, you know, we can't tell law enforcement to do their job or how to do their job, but we can hopefully try to create lines of communication in order to reach out to the law enforcement agency to try to open up those lines of communication, right? And so I had a very similar case just this week where, not exactly on point, but basically the certifying officer was refusing to sign because they said that the detective went back to the victim and the victim recanted the story. And I was very surprised by this. So then I and my colleague actually reached out to the client and got some clarifying information and found out that there had been follow-up reports that the client had made with the detective. And I don't know if the detective just didn't update their system or what, but the client reported, subsequent information to the detective, helpful information, and that the first time the reason they recanted was because of influence from the perpetrator of the abuse, actually. So in explaining all of that to the certifying officer, then they took all of the information into consideration and decided to certify. Okay, so that's not going to happen in every case, but you can at least try. Additionally, something that we haven't mentioned here is that Illinois has some really helpful laws to protect immigrant victims of crime who are applying for e-visas. We have the Trust Act, and we have the Voices Act, and we have the Illinois Way Forward Act. And I'll put links to those in the chat so that you can look those up in your free time. But we have some really great laws here to help protect immigrant victims, and that's due to a lot of advocacy on behalf of immigrants and immigrant rights organizations here in the state of Illinois. So back to that question, if none of that works, I would look to see if there's another agency that could potentially certify the crime, such as the state's attorney's office, a prosecutor, or a judge, right? I don't know, Liz, if you want to add anything to that.
No, you covered it.
Okay, I'll move on to the next slide.
Yeah, so here's just a list of referrals for counseling and other helpful things. For anything that you don't see here, obviously, please reach out to us and we'll try to help. You can move on to the next slide. Right, so here's our contact information. As I mentioned earlier, feel free to reach out to both Trisha and I through email or through phone. If you're interested in working on a case, reach out to me. Also look at our website. Here's our general contact information. And we just want to thank you, really. Thank you for joining us today. We hope that it was super informative, super helpful. And so we would like to know what your thoughts are, right? And so we'd like you to fill out this quick survey. We have a QR code here that you can use. The link is also posted here, and I just sent it in the chat as well, so that you can fill it out. It helps us make sure that our pro bono programs are running, as best as they can. And for whoever is interested in Illinois or Indiana CLE credit, please make sure to fill out the survey. Send me your ARDC number if you didn't include it when you registered, so that you can get that credit. And I'll be sending out more information on that after the presentation. So we'll just give folks a bit of time to do that. Know that you'll also be receiving our newsletter and a follow-up email with all the resources that we mentioned, including all the slides to this presentation, so that you can refer to them as you're working on that future e-visa case.
Bear with me, I am adding more information in the chat of the various laws. We actually ended up early. This never happens with us. So please jump in if you have any questions. And you can always reach out to us after the fact too. Oh, very great question, Allison. What is the process for taking a case? Liz, you go ahead with that one.
That's a great question. So you could just reach out to me or any of the contacts that you see on our website that could lead to me. We actually do have a case right now that is in need of pro bono representation. I'll be sending more information on that through email. So please check that out, reach out, and if there's any more questions on that, just let me know. We'd love to work with you and anyone else who is interested. Now that you've already participated in this training, you should definitely be ready. And so we do encourage you to take on a case if you can.
Liz, here's another question for you. Whether advanced parole is available if they are granted deferred action. I assume no, based on the U visa potentially being denied if they depart the US, but why don't you go ahead and take that while I look up these regs.
I'm sorry, Trisha, I didn't get to hear the question.
Oh, sorry. Whether advanced parole is available if somebody is granted deferred action.
Oh, well, I'm not sure about this one. If you can help
No, of
out.
course, I can answer it. Yeah, so advanced parole is actually not available for U visa applicants, and I do think that the I-131 instruction might still be wrong, and I think that they might say somebody can apply for advanced parole, but you can't. What can happen is a client can leave the United States and process their U visa from abroad, but they would not have a means to legally re-enter the United States, right? So they would have to wait outside the country for their U visa to be processed and adjudicated. And if the U visa is approved from abroad, then the client would have to consular process. But there's no mechanism for them to have advanced parole or to legally return to the United States until that U visa is approved. So for example, a client can actually apply for a U visa from abroad, or a client could apply here and then leave and wait out the process, the multiple years, or if the case is almost about to be approved, leave shortly before it's approved, but then they would most likely need a new inadmissibility waiver if they trigger any additional grounds of inadmissibility, such as unlawful presence. So that's, somewhat complicated, not impossible, but if that were to happen, we would walk you through that. Okay, so I think we've answered all of the questions that people put in the chat. If you think of anything after the fact, please don't hesitate to reach out to us. And if you're interested in taking a case, please do reach out to us. We would love to work with you. And if you know other folks who are interested in taking on cases who didn't get a chance to participate in this training, we will have another one coming up in the coming months. We will also have a training on VAWA, the Violence Against Women Act, coming up in April. So please stay in touch with us on social media or reach out to us directly so that we can make sure you're trained and ready to take on a case. Any last words, Liz?
No, just our break was cut a little short, so I think now's a good time to end. Thank you all. for joining us, and I'll be reaching out to everyone that participated today after. Thank you.
Thank you. Have a great day.